Good afternoon. Hi, it's Tracy B from the Divorce Solutionist. Hi, I'm here for Thick of It Thursday. Excuse my attire. It's summer here, and so my days are usually filled with summer type activities during this time of year. So I'm dressed um, actually accordingly. Anyway, for the last couple of Thursdays, I talked about working with your attorney, right? And I gave some insight about how to effectively work with family law attorneys, particularly, and how to make the most of your relationship with them, how to not be how to minimize, I can't say not be disappointed, but how to minimize disappointments when dealing with your family law attorney. Um, you know, as I explained repeatedly, a lot of people complain about family law attorneys and working with them because, and the major complaints are that they don't, communicate well, that their fees are ridiculously high, and that they pay these fees and they wind up getting shafted with respect to the outcome, the overall outcome of the case. And a lot of people complain and ask about um, filing, formal complaints against their attorney, um, how to go about requesting a refund, how to fire the lawyer and get a new lawyer, how to make that transition a smooth one, how to not piss off the judge by repetitively changing attorneys, and so on and so on. So, but the complaints are usually the same. It's usually those things I just mentioned: the communication, the exorbitant fees, and a lot of time the unprofessionalism or the the disappointment in the delivery of the outcome of the case. That part, that one, and I usually tell people this because I'm very candid. Number one, when you hire a family law attorney, one of the things they should not do is give you any kind of guarantees, because they don't know. Every case that I've handled, and I don't care how many similarities and overlaps the cases had, every case is different. Every single case is different. What we can do is give you some sort of probability because of our familiarity with the law, with the judge, with the procedure, with the facts of your case, even with the other party's lawyer, blah blah blah, all of those things. So we can give you a probability of an outcome going one way or the other. But to give you any kind of guarantees or insurance or assurances, they can't. And if they do, then you need to run. You need to not walk, but you need to run and go find somebody else because you don't want somebody like that. And that will, because, and I say that because being disappointed with the outcome of your case is not necessarily something, well, sometimes the lawyer can rectify that or assure that that doesn't happen. But a lot of times it's out of, it's out of the lawyer's hands. And that's because a lot of surprises happen in family court. A lot of unexpected things happen. I mean, things that, and when I do my strategic action planning with my clients, I try to foresee surprises based on the facts and the background of their case, even based on their personality. But there's no way to know every single surprise that's going to come up. And so when that happens, that can take the direction of your case in a totally different direction. It can completely throw everything off. And so that's not the lawyer's fault. That can be, like I said, that can be a myriad of things, or it can be, just that's just how it goes. So when people come and complain to me about that, I usually say, well, sometimes if it's my client, then I want to analyze everything. I want to read the transcripts. I want to see notes. I want to see discovery. I want to see emails. I want to see all of that stuff to help them figure out if that's what it actually was. But at the same time, um, if that's what their complaint is and they wish to make a formal complaint and or request a refund, that's a tougher fight because any jurist knows that there's no way that your lawyer can give you an assurance of how your case is going to turn out. So that can be a subjective argument, a subjective position that, the lawyer or anybody else who's reviewing your complaint could take. There's no right or wrong. So if that's your sole basis for being, discontent with your lawyer, then my suggestion is to go back and work out, strategize, figure out a way to improve communication, um, you know, make sure you're filled in on everything that's going on as it comes up, because that helps. Sometimes the lawyers get these surprises and they don't tell you. So by the time you get to court and you realize something is going on that you didn't have a clue about, it's already too late. So you can help yourself. But which brings me to the point of today's Thick of It Thursday. Um, you have rights. You have rights. So there's this thing called the American Bar Association. It's the biggest, it's the bar association, it's the national level bar association for every state. So every state has their own version of a bar association, but the American Bar Association is a bar association that lawyers from any state can join. They give they issue what's called like guidelines and standards of practice and rules and all kinds of things. And what most states do within their own bar association or similar, they they use that as the guideline, as the umbrella of how they issue their own rules, how they come up with their own rules. And those rules have to do with ethics, standards of practice, things that have to do with the practice of law and how it's done, how the lawyers behave, how the courts move, and et cetera, et cetera. So the American Bar Association has its model rules, and some of those rules have to do with how lawyers actually interact with clients. And because of that, I didn't have the time to look, but I know most states have a set of rules that lawyers have to follow that also apply to how lawyers interact with their clients. And some get as specific as to dictate how matrimonial or family law attorneys interact or deal with their clients because of the nature of family court matters, family law matters, and the emotional component. Most states, I should have looked to see which states. I know New York does. Um, One rule is you can't, have a romantic relationship with your client. Um, and it's specifically, I think, for family law attorneys, I think I think that's the rule across the board, but I think I remember it being specifically for matrimonial lawyers because of the emotional nature of divorce, custody, whatever it is, case. So anyway, in that, most lawyers, well, let me go back. I wish I had taken the time to actually go through each state. I had such a crazy day though. So some states have what they call no, all states have what they call ethical rules, right? And in those ethical rules, one of them is uh the I want to say standard. It's a guideline for lawyers and how they communicate with their clients, how they interact with their clients, how they report to their clients, how they make decisions for their clients, et cetera, et cetera. Um, One thing that some of these rules actually dictate is that clients be given a statement of client rights and responsibilities in family action. Okay, I'm reading, I don't know which state this is, But several states, if not all, have something very similar to this. It is a statement. It's a client's bill of rights. Okay, and most of the states that do have an official formal client's bill of rights, they modeled it after the American Bar Association standards because they have one. Some states copied it word for word. Some of them, uh, uh, what do you call it? Edited it, or made their own version of it. Some, I'm assuming some don't. I will go back and see which states don't actually have a formal, official client's bill of rights or client's rights and responsibilities. And this statement or this list of rights and responsibilities should be given to every client. Every client, especially in family law, when they sign a retainer agreement, in my retainer agreements, it actually had a clause in there where the client had to initial that they actually received this. And that's the way I covered my behind, because New York actually had where you're supposed to. And I did. I gave my client the client's rights and responsibilities, and they actually had to initial a specific provision or section of the retainer agreement where they acknowledged that they actually received this. Whether they read it or not, I don't know, because I would just give it to them and tell them that they should read it, but I wouldn't sit there and read it with them. If they had questions, of course, they could always ask me about that. But, I dealt with adults. I give them the client's rights and responsibilities and explain to them what it is, and whether it was up to them what they did with it. But anyway, the responsibility for me was to give it to them and to have them sign to acknowledge it. So I want to go through some of the things that are in clients' rights and responsibilities. I'm not going to go through it all because it's a lot, but I wanted to just spend some time because I so many clients, so many, not my clients, so many people in my audience have no clue that they have rights, that they have responsibilities too, because the responsibilities usually mean you have an obligation to do your part as well. But some of them don't, a lot of them don't even know that they have rights as a client. I mean, never mind the fact that you're spending your money with someone, the lawyer, and you have a right to ask certain questions just because you're spending your money. But a lot of them just don't know that they have the right to ask for certain things or to even expect certain things from them. Never mind the rights that you have as a client when you're in court, the rights you have as a litigant in court. That's another, I'll do a live on that one. But I'm specifically talking about when you're working with a lawyer. And it doesn't matter if the lawyer is paid or if it's a pro bono lawyer or if it's a what do you call it? Like the lawyers from the nonprofit, from the domestic violence shelter. It doesn't matter. You still have rights. As long as the relationship or the dynamics is client attorney, you have rights. You have rights as a client. So clients have the right to have their attorneys diligently advocate their interests within the bounds of the law and legal ethics, right? So what does that mean? That means that your lawyer does have the obligation to use ethical measures and to work within the guise of the law, okay? What does that mean for the lawyer? We know what that means. What does that mean for you? That means you can't ask your lawyer to do unethical things or to lie under oath or to break the law just because you're paying him. You don't have the right to do that. Your lawyer has the right to work ethically and within the confines of the law, period. Now, what people do, behind closed doors, don't have any control of that. Clients have the right to have the fee arrangement fully and completely explained prior to signing the agreement. This is one of the most important rights that clients have that they don't know. They don't know it, so they don't exercise it. So what happens? They get their first invoice and it's $10,000 and they're wondering why. And they call the lawyer, they email the lawyer, they text the lawyer and they're asking, how did I accumulate $10,000 in fees so far? And the lawyer says, oh, because you emailed me You called me, you text me, you submitted all these documents you wanted me to review. You wanted me to see your kids' artwork. You wanted me, all of those things I had to charge you for. And your thought is, well, wait a minute. You didn't tell me when I was doing that I was going to be billed for that. Yeah, but it's in the retainer agreement. You didn't read it? No, you didn't tell me to. I just signed it. No. If nothing else, and I talked about this in the last two lives, you have to understand how you're going to be billed. That is important. So many people have come to me, either directly or indirectly, questioning their bill, asking about their invoices. Is this legal? Can they do this? Can they? Well, what does your retainer agreement say? How is your attorney billing you? Oh, I don't know. I didn't look at that. You didn't look at it and he didn't explain it to you? No, he didn't explain it to me. I just signed it. Well, why would you do that? Why would you do that? Oh, because I was desperate. Time was of the essence, blah, blah, blah. Yeah, but at some point you had time to go over it, right? And you didn't. Yes, granted, the lawyers should have definitely reviewed certain provisions of the retainer agreement before you signed. But even if they didn't, it's your responsibility. Remember that part where I said clients have responsibilities too? You can't shift all the blame to the attorney or to the judge or to whoever. You have to accept some responsibility yourself. And if you have questions or there's no reason why you shouldn't have a list of questions before you go in to speak with the attorney. And one of them should definitely be, how do you bill? How will I be billed? What will I be billed on or for? Clients have the right to have a written retainer agreement describing the financial terms of the relationship between them and the lawyer. Absolutely, without a doubt. A written retainer agreement that should be clearly understood before signing. And I know, I get it. A lot of times time is of the essence. The lawyer wants your check or your cash or your money, whatever, and he wants you to sign it because as soon as you sign it, you're gonna exchange, you're gonna turn over the money. And so they're rushing you and they're, encouraging you and, pressuring you to go ahead and just sign and give them the money because they have other things they need to do. They want to get to work on your case really quickly. No. Even if you have to do that, you tell them that you will want to go over the retainer agreement almost immediately after, at the first free moment they have, or that you will review it on your own, because you can do that too, and write out your questions or take note of your questions. Mark the retainer agreement and call back or email with the questions that you have about particular provision. You should do that sooner rather than later. As a matter of fact, if you do that, or if they pressure you or rush you, you can ask them if you can have a 24-hour grace to rescind the retainer agreement that you signed and get your money back, because they were the ones to rush you and not allow you the time to go through the retainer agreement or not go through the retainer agreement with you. That's fairly reasonable, because some of them, once you sign that retainer agreement, you're not getting a dime back. Right, wrong, or indifferent, there may be a provision in the retainer agreement that says under no circumstances will you get a refund. Whether or not they can do that, whether or not the committee will allow them to keep your money if they didn't do anything, that's another story. But why would you even want to get to that point? Because in the meantime, your money's being held up and now you still need a lawyer. You still need a lawyer for your case, right? So to avoid that, if they're going to rush you to hurry up to sign the retainer agreement without, going through it, without explaining it to you, without allowing you ample time to read it and ask questions, then ask them for a 24-hour grace period where you can rescind the contract, the retainer agreement, and get a full refund, or a refund, minus how much you've already incurred up to that point. That's fair. That's fair. The point is, you should understand the retainer agreement. You should know. They should explain it to you in depth, and you should know exactly what's in it, exactly what you're signing. Clients have the right to refuse to enter into any unacceptable fee arrangement or modification of a fee arrangement. That's self-explanatory. You know, if you don't feel comfortable with the fee arrangement, someone asked I think it was last week, someone asked about a contingency fee arrangement in a family law matter. Two people asked that. And I was baffled. Like, why would you think a lawyer would take on a family law case on a contingency fee basis? What would be their incentive to do that? And I think one of them, it was a custody case. She expected a lawyer to take a custody case on the like, why? Who's going to incur all that time and effort to hope that they get paid at the end? So, I mean, of course, that's beneficial to the client, but say the lawyer, flipped that and said, give me 10,000, and if I don't get you the outcome that you want, then we're even. If I do, then you owe me another 20,000. That's an example of an unacceptable fee arrangement. Of course, they can do that, but word it differently, because some people do charge a flat fee if a case doesn't settle, and if it goes on the trial track, they do charge you extra for that. That's different. But my first scenario, that's something like that's typical of an unacceptable fee arrangement that you could actually say, nope, I want no parts of it. Clients have the right to be provided information as to the attorneys who will be primarily responsible for their case and all the other legal staff who will be working on it. And I mentioned this last week as well. You want to know that. Way too often, one of the consultations I did a few weeks ago, actually it was a few months ago, the woman mentioned to me that she was working with a firm, and the lawyer that she hired was good, but he left. And so he handed the case to another lawyer who was completely opposite of the lawyer that she had. And she felt stuck because she already paid the firm for the case. So even, trying to take her case elsewhere, she would have to come up with another retainer fee. And the firm basically told her that, like, sorry, you paid us and we're not going to refund you. It's not like nobody's handling your case. You just don't like the lawyer that's handling your case. And she might have had a legitimate concern. The problem is, like the lawyer said, you have a lawyer. We replaced the lawyer. You paid us. We're not going to refund you because you don't like the lawyer that that's handling the case. And granted, they may not have seen that coming either. But see, and that's another thing about working with a law firm as opposed to a solo practitioner or a small firm, a medium-sized firm. The dynamics is very different. I think did I do a blog about that? Or did I do a comment about that? I think I did a topic in my group or blog about that. I don't know what it was, because I usually talk about what my audience brings up. And so I think I addressed that. It wasn't too long ago. I have to go back and look. But anyway, there are pros and cons of working with a mid-sized firm in family law matters as opposed to solo practitioners or smaller law practices. And me, because I was on both sides of the table, I don't think I would ever work with a firm in a matrimonial or family law matter unless I was going through a divorce and it was like there was a lot of assets involved, and the assets needed to be evaluated, need to be located, something like that. I think that's when I would use a firm because they have more resources. But if it's just a straight divorce where we have to split up assets and debts, and we have to work out custody and child support, I don't think I would do a large firm or even a mid-sized firm. I think I would stick to like a solo practitioner or like a small firm, because the chances of you your case staying with that particular lawyer, and that lawyer being accessible to you a lot greater with a smaller office. That's me. That's my preference. Um, Only in, like I said, family law matters. And other things, there's other pros and cons that may, switch. But for me, if it were me, with a custody or a divorce or something like that, I think I would rather do a solo practitioner, and not just any solo practitioner, or like a small firm where there's like 2 or 3 lawyers and a couple of support staff, and that's it. You know, because it's a little bit more intimate. Even if a lawyer in the office had to cover for another lawyer, chances are they already are familiar with your case, or they talk about it. It's that's my take on that. Okay, let me do a few more because it's already 25 minutes into this live. Uh, Clients have the right to be billed on a regular basis. That's another thing. That's another thing that I myself, and when I first started out, I had a problem with billing because it's so tedious, until I wind up hiring somebody to do it for me. But you have to. And I was in one group on Facebook, and one woman said she didn't get a bill. She had a first bill, I think 60 days or 70 days after hiring the lawyer. And the stuff that was on the bill, it was so astronomical. And I asked her, I said, why are you just getting your first bill 60 or 70 days after retaining this lawyer? She said, I don't know. I kept asking him for one and he never did. And he finally sent me one, and look, and this is all of the charges on there. And I said, well, what did your retainer agreement say? And of course she never answered. And so that I took that to mean she didn't read it, or she didn't have one. But I told her, I said, you have to be diligent. You have to be diligent about getting a bill every 30 days. I mean, if it's late by a week or two, that's acceptable. That's okay. But you can't wait 60, 70 days. And, and she did try. She said she tried. But you know what? Sometimes when lawyers don't answer you, go to their office. Go and show up, do a pop-up at their office, because they're obligated to communicate with you, especially some questions that you ask. Some questions are redundant, some of them are, to us, it's like common sense, but some questions, and no affront to anybody, but some questions are that you are entitled to an answer. You are entitled to, even if the answer is, I have nothing to report. If you're asking a question, especially about a bill, about billing, when are you going to send my bill out? I'm waiting for my first bill. Yeah, you're entitled to a response. So, and the rules say that the bill should be sent out every 30 days. Some places, I think it's every 45 days or 60 days, but I know in New York it's every 30 days. Okay, last one. Clients have the right to be informed of and be present at any court proceeding involving their case unless otherwise directed by the court. And I don't know any instance where the lawyer would say, oh, I don't need you at court, don't come, and you say, but I want to be there, and they insist that you don't go. I mean, I can see that happening when the lawyer knows that they're not going to be present and they just don't want to say that, or when they know that they don't want you to take a trip and, possibly drag out the court appearance, where it could be something that could be taken care of in 5 minutes. The mere fact that you're there, it drags it on for 35 minutes, something like that. But you have the right, whether they tell you no, 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 but you want to be there anyway, you have the right to be there. If the judge says your presence is excused for whatever reason, you still have the right to be there. You still have the right. Whether the judge allows you in the courtroom now, that's something different. But you still have the right to show up. Okay, that's something that's pretty much standard. And comes, and your lawyer insists that you don't show up, even though you insist on showing up, you need to know why. You need to know why. So anyway, I'm going to stop right here. That was 7. When I come back next week, I'm going to go through another several of them, and I'm going to explain them. And I'm going to give you some scenarios, and I'm going to answer that one question that I had. Anyway, let me just bring you up to speed to some things that's happening. So I'm currently working on my first book. Divorce is Chess. Everybody who knows me knows I'm a strategist, and what I do, I compare it a lot to the game of chess, um, because family court is a game of chess, and my focus is to help people see it that way so that they can increase their chances of winning or getting outcomes that they want. So my first book is going to be an overview. It's not going to get too in detail because I'm going to break it up into volumes. But the first book is going to be it's going to discuss how I view family court from the perspective of a game of chess. It's I forgot what they call it. There's a term for that. Anyway, I'm hoping to have at least the first chapter released before the end of the summer. I'm going to release the first chapter free to a certain number of people and get their feedback to see what they think so that before I release the remainder of it, to see if I need to, maybe tweak some things or, blah, blah, blah. So look forward to that. If you're not in any one of my groups, please join. It's the Divorce Glow Up on Facebook, and the other one is Pro Se Divorce in Custody on Facebook. The Divorce Glow Up is for anyone who is going through divorce, custody, blah, 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 whether they're represented or not. It's more of a support. It's the intentions of that group is to help you get through the emotional, the mental, the spiritual, all of those components of the divorce process or the custody process. So that group is more of my perspective from a coach perspective because I coach as well. I do divorce coaching or family court coaching, and when I coach, I focus on the total, complete, holistic picture. Not that I don't do that in my other group. My other group is more for people who need that guidance in their pro se case. They need more of practical, hands-on guidance and insight and resources. So that group is more geared toward people who are pro se and who need, instructions on how to complete a form or where to file a form or those kind of things, right? So you can join any one of those groups. I'm always every day I post something different. There's a different theme for every day in both groups, except Saturday and Sunday. I take those days off. Well, occasionally I may put some self-care stuff up, but anyway. You can follow me on Instagram at The Divorce Solutionist. I'm on LinkedIn at The Divorce Solutionist. I'm on Facebook as The Divorce Solutionist. My website is thedivorcesolutionist.com. I have a YouTube channel, The Divorce Solutionist, but that YouTube channel is pretty much the same as what's on my lives. Occasionally I'll add something there, but it's just getting up and tweaked and perfected. So right now, it's just a stream of what I do on my Facebook lives. I blog every week, so if you visit the divorcesolutionist.com/blog, you'll see all my blogging that I've been doing for the last few months, which usually talks about a topic that's different from what I discuss in my lives. Sometimes it overlaps, but not often. I usually talk about something different there. But so anyway, look forward to those, my book, eventually I'm going to do a course. I'm still working on the Pro Se trial prep workshop. I'm not working on it. I took a pause. Because I had another recent death in my family. And this 2020 and the first part of 2021 have been, I can't even talk about it. But anyway, so, but I am going to finish up the Pro Se trial workshop sometime within the next few months. But I'm definitely going to finish the book. I'm going to at least finish the first chapter and release the first chapter. free to my audience so that you can get an idea, get an insight of what the book is going to be about. Hopefully you will reach out to me if you have questions, if you have comments, if you have, insight, input. You can DM me here on the Divorce Solutionist Facebook business page, or you can DM me on my private page, Tracy B. Or you can send me an email at divorcecoachesq@gmail.com. Anyway, until I see you guys again next week.